Hi, folks. Welcome to the first lecture of MAN4320. This is a course on staffing, so we're going to be looking at the world of staffing and what it encompasses. And today we're going to start out kind of giving an overview of HR, kind of how I structure things, and then we're going to look specifically at the legal environment in which we deal with staffing within the United States. So, a little bit about me to kick off. So I am Kevin Brown. I'm your instructor for this course. And I've been teaching at FIU since, I guess, about 2000. I'm an industrial psychologist by training. And my real job, my day job, is Vice President of Human Resources for U.S. and Latin America for a global engineering firm called SNC-Lavalin. So we have about 53,000 people globally. So I know quite a bit about human resources within a very large business. Certifications, I do have my SPHR as well as my SHRM SCP. So I've been doing this more than, I guess, going on about 20 years or so, or I just passed 20 years. So a fair amount of experience of actually doing what we're going to be talking about. So before we get directly into staffing, I'd like to give a little bit of review into what human resources management is in total and what human resources as a field is and why those of us that are making this our career seem to be attracted to it. So what is HR management? Basic definition I've put forward: management of every facet of the employee lifecycle from acquisition, which means recruitment and selection, development, retention, and ultimately termination. So it's the entire lifespan of an individual within an organization. So within that area, within a human resources, there tends to be 6 primary areas: compliance, staffing, development, rewards, performance management and discipline, and HR systems. Now, obviously, what we're going to be focused on in this course is going to be staffing. Not to say that there won't be some other things that come into play, especially since today we're going to be talking about some of the legal stuff, which is largely compliance, but staffing is what we're focusing on in this course. So why pursue a career in human resources? You know, it's interesting. It's one of those things that I always like to kick out there when we start a new course, and the number of responses, the types of responses tend to vary quite a bit. And I'm pleased to say that I think they've gotten better over the years. So the responses I was getting 20 years ago are quite a bit different from the responses I get today. But it is interesting because nobody grows up and says, you know, you don't have too many 5-year-olds sitting out there saying, someday I'm going to grow up and be an HR director. So it's funny how we end up in the fields that we do. But some of the common responses that I usually get when I say, hey, you know, why pursue a career in HR? I'll get things like people saying, I like working with people, I'm a people person, I like helping people, and when I hear that, I always caution them. And I always say, this isn't exactly what it is. It's not to say that you won't be doing some of that and you won't be working with people, but one of the things that I'm very careful about is making sure that people understand what real HR is, and particularly within a real organization. Now, yeah, if you go and you work for a small mom and pop, you're not going to have a lot of upward mobility, and you know it's going to have this very traditional administrative functionality. But when you get into larger organizations, it's quite a bit different. So, and that moves me into the question of why does HR exist? And the common responses here are things like to protect the employee, to ensure compliance and protect from litigation, recruit, train, and retain employees. All of those things are true, absolutely. The protection of an employee, one of the things that I'm very cautious about, and this kind of comes to those responses before, we're not a corporate social worker. And you should never think of HR as a corporate social worker. We have an interest, a vested interest in making sure that employees are satisfied and happy in their jobs because we want to keep them, you know, by creating systems, policies, incentive processes, and programs, and all that kind of stuff. That's how we get a competitive advantage to go out there and be able to recruit and retain the best staff. But in the end, we have one real reason why we exist and one real reason alone, and that's money. The same as any accounting function, any marketing function, any IT function, any other support function within an organization. The reason you exist is to add value to the business. So how do we create value? We're not going to be generating revenue in the way that, for instance, my engineers do. Instead, we contribute to a company's competitive advantage through different types of things. So certainly here, we're going to talk a lot about it as we go through recruiting and hiring and retaining the best labor resources. And this can deal with the process of recruiting and selection, developing comp and ben programs that are attractive and help to retain. We can also develop and train human capital to exceed competitors. We ensure regulatory compliance. We provide client support, primarily internal client support. So just as an example of recruitment, one of the things that you'll hear me refer to at different times, especially when we actually start to talk about the process of recruitment and selection, there's a big difference in terms of the potential value that an individual brings to the table based on how well we predict who's going to perform what. So if you think about it as an average employee, just an average employee is going to generate somewhere between 2 and 2.5 times their salary in revenue. So that means if you have a $100,000 salary, then that individual is going to bring in about $200,000 to $250,000 that year in salary. Now that sounds like a lot of money. The reality is, for the most part, most organizations operate around a 3.0 multiplier, meaning that they need to get a 3 times salary in order to break even. So with that said, if you're hiring people or hiring folks that are just adequate, you're going to go out of business. So on the up end, though, if we look at individuals who are really good at their jobs, and if we can create situations where we are able to recruit and select and identify those folks, those people can bring in somewhere between 5 and 6 times their salary and annual revenue. And that is substantial. That is a huge amount. So if you think about that gap between 2.5, and then 5 and 6, if it's the processes that we put in place, the tool sets, the skill sets, the technology that allow us to get from that 2.5 to 5 or 6, that's all of our value. That's value that we specifically created and provided. All right, so what is staffing? So this entire course is going to be focused on what the concept of staffing, and I specifically like to use the term staffing because it comprises 2 distinct activities. There's recruitment, which is the process of identifying a group of qualified candidates for open job needs, and then selection, the process from evaluating and ultimately hiring candidates from that recruitment pool. So even though we think of it kind of as an end-to-end or start-to-end process, in reality, they are 2 separate pieces. So the process of recruitment and sourcing versus the actual process then of going through and selecting a candidate and making an offer. So throughout this course, we're going to be looking at those elements, different pieces of recruitment, different pieces of selection, and how we contribute and how we build on all that. So what we're going to start with today, though, is we're going to look at the legal environment in which staffing comes into play and the different laws that kind of dictate a lot of what we do and that we need to be aware of and be cognizant of as we go through this process so that we don't create issues. So employment law as it relates to recruitment and selection. A few things we're going to talk about: the relationship of state and federal law, concept of employment at will, equal employment and opportunity laws, affirmative action, and then some basic tort law or case law. So as we're talking about state and federal law or laws in general, it's important to understand the interaction between state and federal laws. So obviously you've got the federal government. So this is, obviously the president and the Congress and the Senate, and then you have state governments. So the state congresses and governors and stuff of that sort. So in both cases, you've got employment laws that are enacted, and there's some basic rules that come into play. So federal law always supersedes state law. So federal law always establishes that minimum. A state law can never take away from federal law. It can add to federal law. So basic rule of thumb in most cases, satisfaction of state laws generally will put you in satisfaction with federal laws as well, simply because they can't be less than federal laws. So you have to know what's going on in the federal aspect, but you also need to know what's going on in the states in which you operate. So there's a federal minimum wage, but many states also have a different state minimum wage. And so when you're operating in those states, you've got to pay that state minimum wage. There may be certain requirements. Certain states have requirements to carry certain disability requirements. Certain states increasingly have introduced requirements to offer paid sick for all employees, regardless of whether they're part-time or not. Right now, the basic ratio that we're seeing in the handful of states that have done it, being led by California, is about 1 hour per every 30 hours worked. So understanding how state and federal law interact and what you need to know, or how that impacts what you do as an HR director or HR manager within your organization, is paramount. So the concept of employment at will is important, and this is really the doctrine that is the basis of American business. So it's not a specific piece of law. There's not a piece of law out there that you can say, oh, well, this is the employment at will law. It's more considered what we would consider tort or common law. But employment at will basically states that either the employer or the employee can terminate the relationship at any point, with or without cause. So this says that we can terminate, or they can quit for any reason, so long as it's not in violation of basically a contractual agreement, which is relatively rare within the United States, or violation of one of the other pieces of legislation, usually EEO legislation, that would prohibit you from making a hiring or firing decision based on an individual's race, gender, ethnicity, national origin, religion, those types of fundamental protected classes. So we need to be understanding of what that means. So within the United States, we're very cautious and very careful to not give away this employment at will aspect. You know, it's been weakened, but it is still alive and well. And it's something that we're very cautious of. And one of the things that you want to be careful of, as I said, you know, a contract or employment agreement can subvert employment at will. So you need to be careful about things like the intricacies of your employee manual. You want to watch the language in there so that you don't create what we call an implied contract, where you're making commitments to individuals that you're not meant to make. So in any event, we usually do create situations where we're restricting the employment at will within our organizations, simply in the fact that most of us have what we would consider progressive discipline policies. So rather than, hey, you know, we're going to terminate you here, you know, for whatever reason, period, we usually say, for cause purposes, unless it's pretty severe, we're going to go through this due process and give you an opportunity for improvement and so on and so forth. And that ultimately does diminish the ability to claim employment at will. All right, the primary EEO laws. So there's a lot of them here, and we're only going to hit on a few of them really in any depth, but there's a few of them here that are kind of interesting and that I mentioned very briefly. So we'll talk about Title VII Civil Rights Act of 1964, which is the granddaddy of them all. Civil Rights Act of 1991, Civil Rights Act of 1866, Vocational Rehabilitation Act of 1973, the Age Discrimination and Employment Act, Equal Pay Act, Employees with Disabilities Act, Pregnancy Discrimination Act, and the Vietnam-era Veterans Readjustment Act of 1974. So Title VII of the Civil Rights Act of 1964, this is really where EEO legislation, as we know today, was born. And basically, it protects or provides protection for the following class of workers: individuals based on sex, race, color, national origin, or religion, those big five. And what it says is that organizations that meet this qualification, and it includes any employee or any employer with 15 or plus employees, with certain exemptions for some private clubs, religious organizations, or Indian reservations, but it says that it prohibits organizations or companies from making decisions based on these, and particularly, specifically prohibiting the use of these in rejecting or holding individuals back. So you cannot go out and say, well, you know what, I want to hire a white male for this position, or a female can't do this job because she may become pregnant and won't be here long enough, or all those are no-nos, and they're things that I'd like to think that we're beyond, but in today's day and age, I realize that we're not. So these are the big five, and they've been added to with subsequent EEO, and they continue to evolve and emerge, and we'll continue to see additional protected classes as we go through. So a primary element that comes in with this is the concept of discrimination, and we all hear the term discrimination, and so, but we don't necessarily know what it is, or we don't have a firm grasp of what the true definition is. So Title VII prohibits discrimination against individuals based on those five elements. So when we talk about discrimination, though, we have two types of discrimination that we really, or that the courts have defined. So we have what we call disparate treatment, and this is the blatant discrimination against individuals belonging to a protected group. So this is when an individual or a boss or an employer actually says, I will not hire an individual of color to fill this position, or I don't want to have a woman fill this position. So these are blatant, deliberate discrimination actions. Now, the majority of the discrimination that we see out there is what we call adverse impact. So adverse impact tends to be more inadvertent. It's non-purposeful bias against individuals belonging to a protected class, resulting from the use of procedures that disproportionately deny certain groups opportunities or resources, whether it's jobs, promotions, raises, training, etc. So this is a situation where we may be utilizing certain tools that inadvertently tend to create a bias or systemically disadvantage individuals from certain groups from being chosen. And so we have a responsibility as HR managers to ensure that our practices, that our hiring practices and processes are as free of both disparate treatment and adverse impact as possible. So the Civil Rights Act of 1991 is an amendment that came into play and prohibited the use of race norms in selection testing. So one of the things with adverse impact, a lot of organizations said, oh, you know what, well, we can correct for that. So they would go through and they would statistically correct for that. So if you think about it in terms of, let's say, an intelligence or cognitive ability type test where minorities tend to be disadvantaged due to a lot of the cultural elements that are introduced into those tests. So what used to be is that organizations would say, okay, well, if it hurts minorities, or if there's a systematic bias against them, that equates to an equivalent of, say, 20 points, and we'll add those 20 points in there. So the Civil Rights Act of 1991 prohibited utilizing that kind of process. So it really put the onus back on the organization to go out and ensure that they were using or are using tests and procedures that really do minimize adverse impact against protected groups. Second, it allowed for jury trials of discrimination cases, which is big. So with jury trials also comes basically a lot additional cost. So here you're looking at the ability of a jury to award various rewards to a plaintiff if they're found to have been discriminated against. So it goes beyond just damages or reinstatement of a position, but it actually goes to a much higher standard of monetary damages beyond what was there before. Civil Rights Act of 1866, I include this in there because obviously you can tell this followed the Civil War very shortly, and prohibited discrimination on the basis of race and color. And one of the things to understand or to see, this has kind of really popped up over the last couple decades as being a key piece of legislation for enforcing or for dealing with some of the discrimination. Because what it does not do, that the Civil Rights Act of 1964 does, is that it does not have that 15-person minimum for organizations. So there are certain situations where lawyers have utilized the Civil Rights Act of 1866 to bring suit against small employers who are in direct violation and discrimination of protected, in this case, really minority candidates. Age Discrimination and Employment Act. So the ADEA prohibits discrimination against individuals that are 40 or older. ADEA's broad ban against age discrimination also specifically prohibits the following things: statements or specifications in job notices or advertisements of age preference and limitations. So we cannot sit there and say, oh, yes, we need somebody who, nobody over 40 need apply. In order to create an age limit or establish an age limit, or for that matter, any kind of discriminatory type of hiring behavior, we need to establish what we call a bona fide occupational qualification. We need to assert and be able to document and truly justify and support that there is a real reason why we can lawfully discriminate against individuals of a certain class or a certain group or a certain age group. So in the case of, let's say, airline pilots, we run into situations where there are some limitations in terms of the age of airline pilots. But that's what we would consider, it meets what we would call that BFOQ, because certain individuals of a certain age are more likely to suffer from catastrophic health issues that could be truly detrimental to public safety. So we need to be very cautious in terms of doing that. There are times when we can make that rationale, but very, very rarely, and it's usually in the context of public safety. Second, discrimination on the basis of age by apprenticeship programs, including joint labor management apprenticeship programs. And finally, denial of benefits to older workers. So we can't say, oh, once you're 60 years old, we're no longer going to be. So, sorry, I had to go tell my kids to be quiet. So we are not able to go through and say we're going to end certain benefits for our employees of certain ages. What we can do is we're able to reduce the benefits so long as the cost that we're spending is no different than what we're spending on younger workers. But generally, we don't do that. You don't see that all that often. So Equal Pay Act of 1963, the EPA prohibited discrimination on the basis of sex in the payment of wages or benefits where men and women perform work of similar skill, effort, and responsibility for the same employer under similar working conditions. So we see a whole lot of this focus right now. It's great that it's come so much to the forefront. It is still a problem. It's reduced dramatically over the last 2 generations, but it's still there. So I think right now it's about women generally make about 86 cents on the dollar for their male peers or counterparts working in the same roles and positions within their business. So still a long way to go. So this has gone, fortunately, a lot of attention lately, and we've made some progress in certain things. One of the interesting things about the EPA is that it is one piece of EEO legislation that has a unique relationship with the EEOC. The EEOC is the legislating body, the body that basically does the investigations into claims of discrimination. And it was created in 1964 with the Civil Rights Act. So in contrast, the Equal Pay Act predates the Civil Rights Act. It is the only piece of EEO legislation that predates the Civil Rights Act by a year. So you can actually go and file a court claim or court case without going through the EEOC, which you cannot do with any of the other ones. Most recently, in 2009, it was the first piece of legislation that President Obama signed into law was the Ledbetter Act, which required it restored the interpretation of some elements of the Equal Pay Act that had been overruled by courts more recently. So there was a long-standing act that each paycheck basically resulted in or created a new situation or occurrence in which uh, the the pay inequality basically restarted, and that the statute of limitations was extended from that time. And what had happened was there was a kind of an unusual court case that came through. In this case, Lilly Ledbetter, um, where the court came back and said, no, basically the statute of limitations starts at the first instance of inequity, and therefore it all ran out. The Vocational Rehabilitation Act of 1973 uh, is instrumental because it prohibited discrimination based on physical or mental handicaps. Now, this was the precursor to the Americans with Disabilities Act. At the time, it was only eligible or related to federal agencies and federal contractors. So there was a large portion of the population or the business population that was not, for whom this was not applicable. So with the Americans with Disabilities Act coming into play in 1991, it expanded a lot of those benefits and clarified or made them much more accessible throughout. So the ADA prohibited discrimination on the basis of disability in all employment practices. So what it also did is it went through and it created some new definitions and some new concepts which have been fleshed out through case law in the years since. So the ADA identifies an individual who is disabled as a person who is defined as disabled as follows. They have a physical or mental impairment that substantially limits one or more major life activities. They have a record of such an impairment, or they are regarded as having the impairment. So that last one is important because it's not just saying that you have an illness, but people think you have an illness. So let's say that you have a certain illness that manifests in a way that people think you have something else. And even though you may not have that disease or that impairment, the mere fact that people assume that you do uh, it can qualify you as disabled regardless. So ADA does not give a preference, just like Civil Rights Act, any other protected statuses. You know, one of the things that's critical to realize is that this does not create or allow companies to provide a preference for the protected groups. And individuals must be qualified and meet the job requirements with or without reasonable accommodation. So in the case of disability, it introduces this idea of reasonable accommodation. And a reasonable accommodation is an accommodation that an employer makes so that an employee can do that job. So what is reasonable depends and is interpreted against the business. You know, so we're looking at what does not create an undue burden for the business. So for smaller businesses, that's going to be different than for a large business. Most of the time, these tend to be physical adjustments or additions that need to be made, whether it's the construction of ramps, the construction of wheelchair accessible restrooms. If you think about it from a bank situation, so having teller stations that allow individuals in wheelchairs to do it. So those are things that are reasonable accommodations. Now, there are situations, again, where you can have a bona fide occupational reason why you could not hire somebody with certain disabilities. So, for instance, if I were working in a steel company and I had people who were building high-rise buildings, I couldn't hire somebody or expect somebody in a wheelchair to be able to work on, you know, the open steel on the 90th floor. Pregnancy Discrimination Act. PDA is an extension of the ADA, as well as the EEOC. The Pregnancy Discrimination Act prohibits discrimination against women due to pregnancy. You cannot deny employment because a woman is pregnant. You cannot deny promotion, raise, or other opportunities because of pregnancy. And you cannot force a woman to go on leave so long as she is still able to perform the basic duties of her job. So those are things that an organization is highly restricted from doing. Now, one of the things that's important to note that's come out in various case law is that pregnancy is not a disability. Now, it may create a disability or contribute to a disability, but it in and of itself is not a disability. Therefore, a company does not need to provide light work to accommodate a pregnant employee. So if a pregnant employee suddenly has restrictions on her work due to her pregnancy, the company is not required to make accommodations for that. So if, let's take the case of a nurse who is required to lift, up to 200 pounds or 50 pounds, or lift, be able to set somebody 200 pounds up. If they can no longer do that due to pregnancy, then they can no longer perform the basic functions of their job. And the appropriate recourse in that perspective is that they would go on FMLA, they would go on their maternity leave, and they would be, basically taken out of the organization until after the baby was born. Vietnam-era Veterans Readjustment Act of 1974 prohibits discrimination against disabled veterans who served in the armed forces between 1964 and 1975. So between Vietnam era. So, this used to be a problem. This hasn't been a problem with military in many, many, many years. But certainly with Vietnam, it was a very unpopular war, and in a lot of situations where people came back and were not treated all that well or that fairly, and where there was some discrimination against veterans at that point. So this created a situation where it prohibited organizations from discriminating against veterans of those wars. Now, there's been some further stuff since that has, provided some additional protections throughout for veterans in general, but there's never been the need to the same level as what we saw following Vietnam. Affirmative action. We all hear about affirmative action, and affirmative action is not a piece of legislation. It is really a series of executive orders. So these are executive orders that actually Richard Nixon put into place. Executive Orders 11246, 11375, and Section 503 of the Rehabilitation Act. And what affirmative action is really gets kind of probably in most cases a pretty bad rap in the media. There's a lot of misunderstanding of what it is. So affirmative action really is a recruitment process more than anything else. It's not about selection. Yeah, we set goals. We set goals to try to increase and improve diversity within our ranks, but there is no such thing as quotas. Quotas are actually illegal unless they are mandated by a judge as a result of usually abhorrent past behavior, past discrimination. So for the most part, there really aren't quotas, and that's a misnomer in terms of how we look at it. What affirmative action really comes down to is recruitment. It really is a recruitment function. It's a matter of going out and identifying populations that are that have the skills that are necessary and provide added diversity. So we may go out and publish our ads on diversity websites, state-run websites, various types of websites. There are certain things we may do for disabilities and so forth. So going out there and really expanding the pool of candidates to be able to enhance diversity without sacrificing or watering down what the requirements of the job are. So affirmative action plans should be a few things: narrowly tailored and short term, not include class-based firings or layoffs, and only used to correct prior discrimination. I always try to make people understand that affirmative action is kind of thought to be similar to an emergency plan. So you're supposed to have it on the shelf, and it's there, and in the event that you need to take it out and enact it, you do. But it's not something that's ongoing, that's in place all the time. But it's there to correct problems should they arise. All right, so looking at and bringing this back around to recruitment and selection, and looking at some other elements that come into play and how this impacts it. So when we're dealing with recruitment and selection, what we're really focused on in terms of compliance and making sure that we don't create problems is that we want to see consistency of application throughout the process. So everybody should go through the same process. So this includes things like pre-employment testing. So any kind of testing that's done needs to go through and needs to be done evenly and effectively and consistently throughout. Now, of course, we have the things like adverse impact, as we discussed, and various test biases. So understanding and recognizing that and being mindful of that and taking every precaution to make sure we're not introducing discrimination is critical. Background investigations. So we do absolutely frequently do background screening. I do background screening and drug screen on all of my folks that come in. So there's a few pieces that come in. References. So the concept of a reference is where you actually ask people for a reference from a prior employer, and you call and you get information. For the most part, you're not going to get a whole lot of information. What they're going to mainly confirm these days is the dates of employment and possibly the job title. But you're not going to get a lot of other information because there's some other liabilities that come into play, defamation and negligent hiring, which we'll talk about here in a minute. So references, by and large, aren't that useful, to be honest. But we'll do it, we do it to the extent that we simply confirm the work history. So the Privacy Act of 1974 and the Freedom of Information Act, employees have the right to examine letters of reference regarding them. So if you're requiring letters of reference, be mindful of that. And finally, the Fair Credit Reporting Act, which really dictates and guides what we do in general for all of the background screens. So even though this is originally created related to credit reporting, this encompasses any kind of background checks that we do, whether it is criminal, employment history, drug screening, all that stuff comes into play and falls under the FCRA. Medical examinations. So with the ADA, it's one of the critical pieces that there's no pre-offer medical inquiries. So that means that you cannot go in and do a pre-offer medical inquiry prior to actually extending an offer. So you can put out an offer and make it contingent on them passing certain things, certain medical exams, providing you can establish that they are required for the job. So again, if you're hiring a pilot, there may be exams or physical exams that are required to make sure that they are not suffering from arteriosclerosis or other types of health issues that may create a public safety issue. All right. Well, I didn't talk about it, and I'm not going to talk a whole lot about it, but wage and hour law, which is based largely upon the Fair Labor Standards Act of 1938, has come forward, and one of the elements that I'm keen to always be mindful of is the concept of employees versus independent contractors. And this is so critical within the context of the recruiting and selection process. So there are situations where employers try to or have a preference to bring in independent contractors versus employees. And what I try to explain to them is that it's not a choice. An employee and an independent contractor are defined by the government. So that means that, there's not a decision to be made in terms of whether we want somebody to be this or whether they want to be that. It's whether they meet the criteria. So there's a reason. If an employee, then the company must do these things: withhold income taxes, match Social Security and Medicare taxes, include the person and company benefits, pay for unemployment insurance, allow FMLA if qualified, provide any other government mandated benefits. So there's a cost it's having an employee that you don't incur as independent contractors. The biggest one being the payroll taxes, so not making that match. But so when you turn them into independent contractors, the employees are responsible for the full payroll taxes. They're responsible for paying their own income taxes and all of that kind of stuff. Independent contractor, in contrast, needs to meet the following criteria: the ability to set their own hours. They work off-site. They work by project. They're being paid by project. They have an opportunity for profit or loss, meaning that if they go over the number of hours allocated, they have the possibility of losing money. If they finish it in less time than they projected, then they have additional profit. They furnish their own tools and equipment, and they are self-employed or working for a leasing company. And so there's an IRS 20 factor test that you can look up online that gives you some additional detail, but those are the primary things that we're looking for to create those distinctions and understand the distinctions between independent contractor and employee. I-9 record keeping. So one of the elements that we're responsible for as HR managers and as organizations in general is to ensure that individuals who are working for us are entitled and eligible to work for us, that they can legally work within the United States. So I-9 recording, and more recently the introduction of E-Verify for the last 15 years. And this is basically the confirmation or requiring that we provide the documents to confirm that an individual is indeed eligible to work within the United States. So what documents are required? If you do the I-9, you've seen the list 1, 2, or A, B, and C, and a combination of them, and so it's pretty clear in terms of what's there. So in terms of the filing, I-9s must be kept for 3 years from hire date or 1 year after termination, whichever is later. We do not destroy them during their employment, so we only destroy them after employment. I-9 info should not be requested until after hire, and all documents should be kept separately from their personnel files. So we keep separate folders with all I-9 documents, and if you can keep them internally within an HR system digitally that has highly restricted access, that's even better. But we don't. This is information that a manager has no right or obligation to see. Penalties for violations. First is a warning, second is an intent to fine letter, and third is fines and penalties. So it can be substantial if you're not doing what you're supposed to be doing. All right, so going back and looking at discrimination in employment again. So I mentioned the two. I want to give a little bit deeper dive here. So looking again at disparate treatment and then disparate or adverse impact. And we talked about what that is. Disparate treatment being the deliberate, purposeful discrimination based on one of those protected group statuses, whereas adverse impact is typically not purposeful, not intentional. So in terms of how we assess the adverse impact or whether adverse impact exists, we utilize what they call the 4/5 rule, which has been established through case law. And what it says is that if the selection ratio of a minority group is less than 80% of the selection ratio of the majority group, then an instrument is said to be to adversely impact minority applicants. Excuse me. So as an example, here we have, let's say, a test here that looks, and we've got white and black population, 100 whites and 50 black individuals applied, hired 50 whites and 18 black individuals with a selection ratio of 0.5 and 0.36 respectively. So if you look here and you do the adverse impact ratio, so the selection ratio of the black candidates versus the white candidates, if it falls below 80%, then there's evidence of adverse impact. So here, the adverse impact ratio for black applicants versus white applicants is 72%. Therefore, since it does not, actually I got that wrong there, but since it falls below 80%, sorry, I changed this, and it should say there is evidence of adverse impact. I'm not going to go into these next few slides, but I wanted to include them in there. This shows some of the burden of proof in EEO cases and jumping back and forth. So it's important to understand that there is a pretty intense process of going through and a back and forth between the plaintiff and the defendant, justifying the use of discrimination or how discrimination takes place. So you've got both disparate treatment and adverse impact here, and what the burdens of proof are for the different folks in different stages. And then here, again, I'm not going to go into great detail, but the EEO claims process. So if an individual goes through and puts in a claim with the EEOC, this is what it's going to look like. So the discrimination occurs. They have 180 days to file a claim, 300 days if covered by anti-discrimination laws, which generally they are. And then the EEOC is going to go through and investigate. And basically, they're going to have 6 months to evaluate and investigate and make a determination of whether discrimination took place. And then, depending on what happened there, they're either going to find that there is no basis, but there is basis, and they're going to encourage settlement or some kind of mediation, or there is some basis, but no settlement was made, and so therefore they issue a right to sue letter. All of this ultimately goes into issuing a right to sue letter for the plaintiff, regardless of whether they find merit to it or not. But you can't, with the exception of the Equal Pay Act, all other EEO claims process needs to go through this. You cannot just go down to the courthouse and file a claim. Common tort law theory. Some different things that we're going to talk about. We talked about employment at will already. Constructive discharge, defamation, invasion of privacy, and negligent hiring. So constructive discharge deals with when an employer makes conditions so intolerable that an employee is forced to resign. In these situations, while an employer may assert that the individual resigned, any court or anything related to that is going to consider it a termination. Defamation, injuring someone's reputation in the community, either through slander, which is verbal, or libel, which is written. To prove defamation, an employee must show that 3 things took place. Number 1, the report was false. Number 2, the report was made in malice. And number 3, that the report caused harm. Invasion of privacy. And this is tough. Certainly we've got requirements that we protect the employee data, whether HIPAA for medical, whether the employee data for identity theft and so forth, as well as the Fair Credit Reporting Act for any kind of background screening. We've got releases and how we manage that and handle that information. But there is always this question of invasion of privacy, and it's always a gray area. There's always muddy water. People, when you talk about drug screening and drug testing and different things, there's a lot of question in terms of what is an invasion of privacy. And increasingly, the laws have kind of been narrowing that a little bit. So we've had, over the last 5 years, the remove the box from applications, which refers to the removal of the box asking about any felony convictions, etc. And so it's tough. Finding that balance between invasion of privacy and what we say and what we can share is critical and challenging. And then negligent hiring and retention of employees who engage in misconduct both during and after work hours. So from a hiring perspective, if we are made aware of certain things that should have disqualified that individual from being hired, but we hired them anyway, we potentially are setting ourselves up for a situation of negligent hiring. So in this case, let's say that that I'm hiring a teacher, and it's been disclosed to me that this teacher has, or that a particular applicant has been arrested for child abuse or molesting a minor. Well, if I know that information and I have that information and I go ahead and I hire them, and then they go forward and they molest a child under my care, that's a problem, and I can be held for negligent hiring. So it's tough. All right, guys. Well, that wraps up this lecture, lecture one. And so at the end of each lecture, as I mentioned on the welcome letter, I give a code word. And you'll go into the assessment area and see a code word entry point for this for lecture one. And the code word for this year, or for this lecture, is slaughter. So those of you that know me or have had me before know that each time I do this, I give a code word, which is a hairband from the 1980s. I'm a big hairband guy. So Slaughter is a great band from back in the late 80s, early 90s. So if you don't know who they are, check them out. And but that's who the code word is for this lecture. Thank you guys. Have a great night.